Post and Oskee Office Centers want to welcome all of you here at our Park Office Center, as well as all of our other locations, to our Power Lunch, another awesome Power Lunch that we get to listen to one of our valued members, Charlie Goldstein. Charlie's been an attorney. It's my honor and pleasure, by the way, to introduce you, Charlie. Charlie has been an attorney for several decades and focuses on the area of employment law. He's written numerous articles for the Hennepin County Lawyer magazine and other attorney publications. He's been named as the super lawyer by Thomson Reuters. And today he's going to speak to us on hiring for the Solepreneur, so many of whom we post at office centers. We're excited. Lots of gold nuggets to come. Let's hear it for Charlie.
Welcome, everybody. First of all, today is not going to be a comprehensive summary. There's no way in 1 hour to even cover the hiring aspect. There is so much that's out there, local, state, and federal, the law, and regulations, and statutes. So today I'm going to talk about some key concerns. I'll sort of take it in order for what you might be doing as a solopreneur before you hire someone. That's the focus of today. And first of all, my primary goal is to scare everybody. Before you hire an employee, you know the law and you have some guidance and following. Because if you're going to hire an employee as a solopreneur, you're taking a big risk. The employee is going to work out from a business standpoint. That's what you're probably thinking about. The bigger risk is, will you break the laws? Some problem with the employee will bring legal action, even if you don't technically break the law. If you come close to it, or if you're to break the law, a plaintiff's employment lawyer will pursue you, even though you had no intention of breaking the law. Most people think, well, if I don't set out to break the law, I'm not going to break it. That's not the way it works. So if you're going to say at some point when the authorities around you that you were deceived by the employee in some way, might work, might not. If you're going to say that we're ignorant of that law, it doesn't help. Even all these employee protection statutes don't help because court let off everybody who said they didn't know what the law was, then the law would become unenforceable because that would be a very easy defense to make. So that's why we have that way. So today I'm not going to mundanely recite statutes and regulations and laws. I'm going to talk about overarching concerns. And a lot of these employment statutes apply to only a certain number of employee businesses. So some of these regulations and statutes, for example, the Medical Leave Act, they're not of concern to the solopreneur. The other hand, things like break times, other accommodations are applicable to solopreneurs, and the majority of the laws are applicable to solopreneurs. So today I brought with me, if you want to look at it afterwards, primary resources I've enjoyed relying on. One of them, the state of Minnesota puts out a nice resource, Employment Law Issues in Minnesota. Now it's a little dated, it came out a year ago, so you can't rely on it, so I'll talk to someone like me to figure out applying on current law. And then I also rely on a huge number of guides put out by the lawyers education people. And they're only summary guides because some of these guides that summarize the law can be 5 or 6 pages of humongous graphs. Scary that I see a fear in your face. Okay, so there are fines, there are penalties because there are several overseeing agencies, the Minnesota Department of Human Rights, the Employment Opportunity Commission, the Department of Labor. You have to be concerned with all of their definitions. Now, your rights as the employer, I can tell you in one sentence. You have the right to control a person's economic fate. There's whether you're going to pay them, you're not going to pay them beyond being terminated, so you control their economic fate. And you have dominion over them over the course of the workday. Tell them where to sit, what to do, how to become an independent contractor. You lose out if you don't have those rights. As long as you've kept them categorized as an employee and treat them as such under the law, now you can pay where they sit, how they sit, as long as you're not impinging upon some regulations that you have to accommodate how they do these various things. So the other rights that they have, I could recite for you, and it would take me until Monday, because there are thousands of laws that protect the employee, especially taking into account all the subparts of the law. There are easily thousands of legal protections for employees. So primarily, they have the right to humane treatment. They have the right not to be discriminated against. They have the right to breaks, wage and hour laws have to be complied with, respecting their religious beliefs, their privacy, many, many more. So I'll give you an example. When I ran a law office some years ago, and I had a larger operation than what I am now. employees were on the internet, of course, and so I bought a computer monitoring company because I just didn't know how else to control people going on the wrong kinds of sites. They weren't pornographic sites, shopping sites, personal media, of course. And so to control those employees, I thought I'd at least get some control with what they could do with their computers. Well, suddenly there was a mutiny because everybody felt it was imposing upon their privacy, their ability to go on the internet for important reasons that they had. They had some important reasons to use the internet for the very practice we were in. So there's a lot of gray area controlling employees, especially when it comes to privacy issues. So first and foremost, the situation isn't different. There's some, it's like snowflakes. There's some that are similar, but every one has a little wrinkle to it. So there's always some unique aspect to an employment situation, especially ones that go awry. So number one to write down is know the law before you get started. Don't plan on reading and becoming familiar with the law or getting legal advice sometime later after you've had this in play for 3 months. Let's see how those things work out. Because once the problem hits, it may be too late to correct the problem that you've already created. So if you don't have time to read a few hundred pages of law, in fact, one resource I just obtained, in fact, give other people this resource, the information about it. The hiring handbook just came out through the legal education people in Minnesota. This is just all the laws on hiring you want to be cautious of. Scary. So, unless you feel like you could read, you're willing, able, and ready to learn at least that much information, don't even go into the employee area. It's challenging enough to make an employee work from a business standpoint. The legal legalities will be overwhelming. So the first mistake solopreneurs make is they think, well, I can hire somebody and call them an independent contractor. Poof, I don't have to worry about these things. Because now they're out of the category of being an employee under the law in most all respects. And I have the ability not to pay taxes. I can save my 7.5% of Social Security matching. I'm not paying anything into workers' comp or unemployment. And so what you have to be careful of is there are 4 different agencies that have different definitions. They all have their own guidelines for how to determine whether somebody is an independent contractor or an employee. Department of Labor, the EEOC, this goes on. And so if you have someone as an independent contractor, they're probably doing sales. But even then, if you have a certain amount of control over where and how they do the work that they're doing in any respect, you're always much safer to call them an employee. Because the downside of being caught mischaracterizing someone is horrendous. And I'll give you a crazy example you won't forget. There was an employment lawyer in Minnesota going back 10, 15 years. And he was very, very successful. He thought he had the great idea of hiring a number of associate attorneys who would all be treated as independent contractors. And so he had a thriving employment law office going. And eventually the authority stepped in and he was put on business because he owed so much in back penalties, taxes, and penalties. Because as an employment lawyer, he had mischaracterized all of these people. One law firm, there's a well-known case of mischaracterized law clerks, called them independent contractors. Well, the law firm told them what to do, how to do it. They were doing the work of the firm. So it was really a slam dunk for the authorities to recharacterize. Once they recharacterize you, all that money that you would have paid the employee, and fines and penalties, etc. So don't go to that territory unless the attorney advises you that this person squarely fits in the category of independent contractor. And it's not the title nor the designation that determines whether they're an employer or independent contractor. It's what they actually do for their job duties. So if any authority steps in and asks you, why did you characterize them as an independent contractor? You can't just say, well, I told them that when I hired them, that's what I wrote down, that's the title, you call them that. It doesn't make any difference. They want to know what the person's job duties and what control and dominion you have. Those are the primary qualifications to determine whether they're in the right category. So now you go on, now that you've determined you're probably hiring an employee, you have good advice, you could hire an independent contractor. Now you have to decide how you're going to advertise for the position. So you need to advertise broadly. If you do it too narrowly, you could be accused of seeking candidates within a certain geographical area that has a high amount of people in the class, minority or otherwise. So you have to be careful that you put the word out that you have a job available. First of all, make sure you actually have a job available. So companies have a rolling advertisement. So they've got the pipeline filled. The problem with that is if somebody applies and they're turned down or they never get back a response, they could be claiming discrimination because they were rejected. The only reason they were rejected is you didn't have that position. And so you want to make sure that when you advertise, you have something so that they can come back and say, you're not stuck in a position of explaining, well, there's no position available. Well, how do you explain to a judge or a jury that you didn't hire this person in a protected class because you didn't actually have a position? Well, you were advertising for it, then the plaintiff's lawyer has almost a slam dunk case. You discriminated against the person because you've given a phony reason for having rejected them. So I don't know why so many companies run that those ongoing ads that you shouldn't be doing. You want to make sure you put out there a detailed job description so that right away you have the ability to do the work itself. That will disqualify a lot of people for their ability to do the work on the basic job description. It's less likely that somebody will come back and claim that you didn't hire them to be a radio announcer because they don't have a voice. For whatever reason, people can still, for whatever reason they choose, they claim discrimination. If they're rejected and you can't point to why they didn't qualify for that job according to one of the job criteria that could show are actually required to do the job. If you're going to advertise on any of the social media, there are a lot of data privacy and security concerns. So for example, if you're on Facebook looking for people, right away you're in trouble because you could be violated if you're doing anything to violate Facebook's regulations and rules, or anyone could ever point out that you're looking at Facebook selectively or for certain personal characteristics of people. Anybody, for example, is married because Facebook does that. You can't do anything to potentially discriminate on a person's personal characteristics or life situation. It doesn't matter what their personal characteristics are or life situation unless it somehow intersects with the description of the job duties that they have to do. There's what we call the Computer Fraud Act, and that prohibits you from doing anything on people's internet sites that's gathering their personal data that in any way impinges upon their privacy. So it's dangerous territory to go on the internet itself. And so, now that's not to say you can't advertise in various places, but you don't want to go out to places like Facebook and offer to certain people within one of these platforms that could indicate you're being selective according to criteria that are important, or may be important to you, but they can be discriminatory. There's a lot of protected data out there you don't want to be collecting in your files either. So if somebody is in your office or you personally as a solopreneur collecting information about people that are applying, make sure that social security numbers are kept in a very secure place. Any of the personal data, telephone numbers, email addresses, and I advise you to keep them locked up because once you start collecting information, you are custodian of their private information. If it's stolen for some reason, you can be responsible for data theft. Very good. Pretty brave. Okay. There's important steps to take with regard to the kind of data you'll be collecting, so it's best to actually talk to a data security expert to make sure you're doing it the right way in your computer. You also want to have people sign agreements if you're going to collect any data having to do with their past employment. It's okay to ask for a personnel file, for example, for a previous employer, as long as you have the authorization from the person to do it. And likewise, we'll cover this in a while, if you're planning to do any testing for drug use, if you want their credit report, make sure they sign an authorization that allows you to collect that before you collect it. Just go around collecting these things and say, by the way, I've got information about you, would you please sign a consent to be utilizing it to evaluate your application. But there'll be a little bit of jumping around here because they hit on some things that make reference back to previous things we talked about. So also, we're going to be cognizant of the time. We're already at 20 minutes, and there's a lot to cover in 1 hour. So try to get to the end of my list. You can come back and revisit some things. Interviews. Now that you've got the word out, you're bringing people in for interviews, there are a lot of questions you can't ask in an interview. So I'll give you a short quiz. Is it okay to ask somebody if they're a U.S. citizen? No.
No.
You have to ask them because you look surprised. You can't ask them that You can ask them if they're eligible to work in the United States. Whether they're a U.S. citizen doesn't matter. They might be, they may have a visa that allows them, a work visa that allows them to work here,
Sure.
and they're not yet a formal U.S. citizen. Whoever has been convicted, you can issue an additional job offer saying you've got the job that we're going to go ahead and check now. These records are on your authorization to check your criminal background. That's not to say you can't go check it yourself in the background. So don't ask Stuart about, you may not get accurate information anyway in the job interview if they've been convicted or arrested. But you can go down to the county, and the county or the Minnesota Business or Bureau of Criminal Apprehension will be able to give you the information about the convictions. Now, if somebody has been arrested and you uncover that, you still are supposed to be carefully evaluating that, because if you don't, you could be discriminating against people who are more likely to have been arrested because they're in a certain minority. For example, one fellow sued because they did a credit check quite a while back, and he was disqualified for bad credit. He made a claim that more men have bad credit than women. That was discriminatory. If you don't believe me, it's such a caveat. Pretty absurd results. Some judges that are very, very liberal about all these things. You have daycare, you have back at a certain point to get your children off your daycare. And ask that because it has to do with familial status. What about if they have foster children? It's not their legal children, no, foster care. That's considered a family status, so you can't ask them if they have foster children. And you can't ask them any questions that even imply these questions. So, for example, if you're about to adjourn the interview and it goes late, you can't see, you hope I didn't make it late to pick up any kids you might have at daycare. You'll grab that and say, oh, she brought up, you have children at daycare and I didn't get the job. There'll be a settlement in that case. And watch out for the tricky applicant who comes in and they actually bring up a question that may lead to an answer, or the question itself may cause you to say some kind of comment in response that could be seen as discriminatory. So when you are asked a question of any nature that has to do with prohibited questions, prohibited categories to ask about, you want to say, what you just brought up is something I can't discuss, and it will have nothing to do with whether you're hired or not. Then make a note that they said that. Make a note how you responded, so that you can show a contemporaneous note that recorded this conversation. What about whether the person can travel the job? That's when you can ask, because that has to do directly with the criteria for
The job description.
right, what the position requires. If they say, no, I can't because my wife's home in a wheelchair, say, okay. And then you just tell them, well, this job does require travels, so you probably want to cut the interview fairly short, because now you've got something that clearly shows they're not qualified for the job. You can tell them this job requires travel, this is not going to work out. If you continue the interview, there's actually a danger, because now the person can say, well, they kept interviewing me for an hour after, so clearly it wasn't the problem that I couldn't travel. What about references? Can you ask a person to provide job references? Of course. And now if you ask another company for references, what do they have to tell you?
They can only tell you if they work there or not.
Yes, whether they work there, the dates of employment, and I'm going to pull out the exact questions. This is a very limited list of what people can provide for references. Dates of employment, if they were dishonest is another one. If I find my list here, I don't want to give anybody one short. Okay, dates of employment, job description, training provided by the employer, they can tell them that, and any written information regarding acts of violence, theft, harassment, or illegal conduct that resulted in resignation, disciplinary or resignation, and the employee's written response to that. So what if that employer doesn't give you all that information? Will you sue them if they come to your place of work and they get violent with people? No, there's no cause of action to sue another company for giving you information that's not complete. They can say, here's what we're willing to tell you about, but it's not required that they comply with these things. These are all the items that they're allowed to give. It's called a qualified privilege. So that means the employer can disclose this information without the employee suing them. So if the employer says, Joe had a bad personality, nobody liked him, Joe might be able to sue if he can prove that was false and defamatory. So that might be a reason that if you're really, really concerned about the background of the person you hire, ask them to sign an authorization to see their personnel file of their current employer. If they have nothing to hide, and maybe have no problem getting an authorization. I believe in great selection, and you can do it based upon work performance, especially if you're hiring them to do the same thing. Now, might they see that as a infringement upon their privacy? Yeah, they might. But if they have nothing to hide, they may not mind that at all. So it's a very unusual request, but I don't really see a problem with asking that. What about, did you find it difficult to go back to school after so many years? Because here they are, they went back to college at age 45, it's a friendly question, it's sympathetic, and you want to get an idea of how much function they have difficult time in school, etc. And ask that, because that implies you might be taking into account their age. So, because you show some special concern about the timing when they went to school. Now, what if they're 20 years old? I think you made some reference to their age. Could you still make a claim for age discrimination? The Minnesota Human Rights Act applies to anyone over 18 years of age, making age discrimination. And under the federal law, anybody 40 or over age discrimination. How about, do you have a visual impairment? You need to know that because you're going to send them out driving a lot. Can you ask if they have a visual impairment? No. You can ask them, are you able to see to make turns in an automobile? Something that's very specific, so that if their visual impairment is in the category of disability, but it doesn't affect their ability to do the job. So for example, if Lisa hires someone who's going to be on the computer all the time, looking at the phone system, and lateral vision doesn't make any difference. The fact that they lack lateral vision, what do they call that? Peripheral vision. If they lack peripheral vision, it may not impact their ability to do the job. So now they're not able to get a job with Lisa because they had visual impairment that didn't actually impact on the job description. What about asking them about military service? It's actually a protected association. Now, if that might affect their performance, if you're asking about how that military duty might affect their performance, make sure you're not asking them questions such as, you injured while you're in the military, so you see you're looking. You want to say that. But you could ask them questions about, I saw in your resume that you were in the military. Did you have any experience working with this type of computer program? Because that's required for the job. You may want to append at the end of almost any question you ask that's job related, because we require that. You have to have that to perform this position. And there's no problem with overdoing that. Keep notes as you go. Have a set list of questions, and you don't stray from it. So if anybody claims you asked an inappropriate question, you can stay in the witness stand. If you're sued, you take it to a trial or a tribunal, you can say I had a set, prescribed list of questions. Or if anybody else, make sure, even if they say they're professional, they restrict themselves to read upon questions. You didn't stray outside of that list. Because if you stray outside of that list, then it's anybody's guess what you might have asked. And if you took those notes the day out, it's a lot more credible than if you show up in a tribunal or a court some long time after the fact, and you try to recall what you said on a given date. And the employee claims they remember it clear as day, they put down, it's clearly discriminatory, and now they actually have a better case than you do from a credibility standpoint because it was clear in their memory at the time they wrote it down. You're just going by memory that you had best when you went to see a lawyer because you were sued for asking the wrong question. So think that you can be sued for asking the wrong question and you spend tens of thousands of your dollars defending yourself, and even if you win, you're out costing $10,000. You have to ask yourself those questions. Is it too much hassle to document so many things? But I could be facing such a huge financially and possibly be found liable if I don't do these things. Any questions about the hiring questions? What about, there become more quiz questions. What about home or vehicle ownership? You can ask those questions. Don't ask them, and it really isn't necessary. Those are questions that are examples of what would be unnecessary unless they can work out of the home or use their vehicle. So I'm saying is there are questions that sound like and probably are innocuous. As long as you relate them to the job description, you should be okay with that. So there are many laws that are implicated when hiring all over the board, and you still have to be cognizant, however, of all the laws that are going to pertain, as we talked about, to privacy. So for those who just arrived, we've talked about employee versus independent contractor. The main point there was err on the side of employee, not independent contractor. There's the penalties and the dangers are so great. We talked also about when you're advertising for employment, advertise broadly. Don't mess around with Facebook or other places where people might see you gather their personal information. That can be a big danger point. And make sure you're not asking in places that could be viewed as discriminatory places to look disregarding large parts of the population. Okay, so now you've interviewed and you're ready to make an offer to someone and put together an offer letter. First of all, this should be the first time that you give any indication to the person that there's any chance they'll actually be employed. Because somebody could even claim that during the interview process, they were told that they were going to be hired. So you could have the most ideal person sitting in front of you. It's always a mistake to say, just paperwork involved, just some technicalities, and then we'll be giving you a call next week to hire you for the position. They might reject another position between now and the time that call them and tell them they reject it. And if they do reject another position, and they claim they didn't take the other position and lost present and future ongoing income because they didn't get the offer they expected. When you put out the offer letter, make sure it's very specific and absolutely show it to a lawyer before you issue that, because the damages can be huge if it's misinterpreted, says things you didn't intend for it to say, especially if there's any representation implied in that letter that they have employment other than what we call at will. This is a good point in which to explain what at will employment means. We've heard that term being bounced around. At will employment means that in the state of Minnesota and most other states, you have the right to terminate the employee at any time for any reason that is not an illegal reason. So illegal reasons fall under general categories. The main categories are whistleblower. You terminate somebody shortly after they report any perceived infraction of a law to your company, and there's any correlation of timing and make that evidence. That's called being a whistleblower. And whistleblower is one of the most popular claims being made now by employees in the courts, that they made some kind of report. In fact, I had a friend that recently in Wisconsin, people were smoking in his office. It shouldn't have been. There was mold in the office that wasn't being remedied. He wasn't being paid the right amount of money for his overtime. Even was not being paid for all hours worked. And so I had him report to 4 different agencies. Now he's being treated like a king because he had some problematic issues in his employment itself. Now they knew that if they were to terminate him, the timing would be such that any judge or jury may suspect that as a whistleblower, he was retaliated against.
Okay.
And I'll come back to retaliation in a moment. Contract violation. If there's any indication that there was a verbal contract or a written contract, the employee can rely on that to get around the at-will designation. So an employee can sue and say, when I was talking to this employer during the job offer process, they made a reference that I would have a job here for life. Everybody here that is here seems to stay for life. Office centers, everybody stays for life. But you want to say that during the interviews. So it's very important to designate in the job offer that you make that it's strictly at-will employment. Also, the person has a right not to be harassed in the environment. There is current legislation that is pending, probably isn't going to pass. When I say pending, I mean it's not actually on the books at all yet, but it's been proposed that if there's sexual harassment that substantially impacts someone's life, that's a general wording, they can come back and sue for it. Presently, it has to be pervasive and and severe. So if there's severe and pervasive sexual harassment, that person is going to be able to make a claim for the sexual harassment. Likewise, say, when I was terminated near that process, I was retaliated against for making a report of sexual harassment. So contract, the whistleblower, other ways that employees can get around this at-will piece. The main thing is make sure you know these employment laws so that you're not violating any laws before you terminate something. That's a topic for a different day. So we're not going to be discussing that today other than job offer letter itself. Now, you also want to make certain that whatever work you're offering them does not violate a non-compete that may have signed with a prior employer. And you have every right to ask them during job interview process and to confirm in a job offer letter that there is not a non-compete agreement they've signed which could possibly be violated rather by what they're going to be doing for you. There's another example, you can sign an authorization that if they're not willing to allow you to see their personnel file for the prior employer, at least have them give you an authorization that you can review any non-compete prior employers. You want to go back 3 years from that. If they have signed a non-compete, I would advise you not to mess with any possibility that you can be in violation of that. They'll be in trouble, you'll be in trouble, because you'll have liability too now that you know about it. If that person skirts that non-compete, they're going to have to answer to that company and the court. And if damages of lost income from the other company, that's totally beyond your control. You have no idea how much that prior company is going to lose by virtue of this non-compete being violated. Now, non-compete agreements, since we're on the topic, time is flying by. We're going to talk about whether you should have a non-compete with the employer you hire, especially if you're hiring them to do work, skilled area that requires that you have loyalty by customers and that you not have them jump away from you in 6 months or a year and try to steal your customers or go after the same market that you're going after. You become your strongest competitor because now they know your secrets, they know your customers, they're in a perfect position to compete against you. So don't try to draft this on your own, of course. It has to be reasonable geographically and in time. So it can't unduly restrict a person's right to make a living. That's the overarching law that relates to non-competes. There's no specific law that says a non-compete must be less than a 20-mile radius, must be within the boundary of the city or within a certain number of miles from your office. You can make it much broader than that. The problem is that you're not going to know if you can necessarily enforce that agreement until somewhere down the road a judge decides whether to enforce it as is or does what we call blue lining. The judge can say, well, here we are in court, your employee went out and competed against you, I'm looking at the non-compete, but it was too harsh, it's too restrictive for that person being able to make a living based on what that agreement says. So the judge says, I think it's more reasonable if you're not 15 miles down to 5 miles, or 10 miles of office, whatever it is. And so now your non-compete has been sliced down to such an extent, it may not be worth nearly as much to you as it was, but it's really the best you can do, other than non-solicitation agreement. That's a little bit different. Non-solicitation agreement means that while they're in your employ and possibly enforceable for them being beyond your employ, but then you're in the category of non-compete again. But at least while they're in your employ, you can have it right in their employment agreement, that an offer letter, that they're not to make any contacts to solicit any present customers. So I once had, I'll tell you a personal war story, an attorney working for me, and she decided she was going to seek a different position as an attorney potentially, and she was speaking with other attorneys that were out there, so she was actually not in the category of someone contacting customers, but employees will feel pretty free to make contacts outside of your company that could be harmful to you. So my advice there would be have pretty strict requirements in your offer letter and stuff that happens at the moment that restricts them from having communication of any confidential data about the company or from soliciting any business from any outside sources from them. Now, next we're going to talk about, you've got the offer letter out, you're going to see if they accept. At the moment they accept, what's the next thing you better have in place? An employee handbook. Now, does that seem like a silly thing to do, so to speak, for a solopreneur? Not at all. For one thing, you're going to need it for adding more employees, and you don't want any claim by your original employee that they were treated differently or unfairly than the ones you subsequently hired, or vice versa. So if you don't have an employee handbook, it's like going out to play baseball without a rule book or without baseball teams have when they go out. not a scorecard, similar to a scorecard, game plan. So your handbook is a game plan, how you're going to cover disciplinary actions, how you're going to cover a multitude of other issues. It could be a 25 or 30-page document, that's how long it should be. A lot of handbooks become outdated, they sit on the shelf. People pick out handbooks off the internet that may not comply to state and local laws, federal laws, and they think they're going to be sufficient just because they have some sort of authority for being posted on the internet. I know there are even paycheck companies that provide employee handbooks, and some are cookie cutter nationwide. I know some are drafted by attorneys or even resource professionals. So you don't want to just grab a handbook from a random source. Wisest, self-interested as I may be to say this, to have an attorney review the handbook, because the cost of an employment law attorney drafting a handbook carefully within the confines of the law is very minute compared to the problems you'll encounter if you try to enforce it and you're being accused of discriminatory. And likewise, if you violate the provisions of the handbook, it could be a violation of the contract between you and the employee. Because the employee handbook, once it's in place, is a contract. Don't let that deter you, because that handbook will also specify that this is the only contract between you and the employee. That nobody can come back and say that some subsequent or contemporaneous with hiring promise was made that there was some other contract with the employee. It helps to supersede that sort of claim in the future. When you go about having a handbook, make sure that the handbook is distributed to everybody in the company, obviously. And you want to carefully distinguish between an employee handbook, by the way, and a procedures handbook. Procedures relate to day-to-day operations of the business. Open the cash register at 9, count the money at 11 p.m. before closing, things that are routine, everyday activities. An employee handbook is about rules and regulations for the employees, which should stay within those confines of the employee handbook. Make sure to have everybody sign that they've received the handbook, so you can prove that they received the handbook and that they've read the handbook. So saying received may not do the trick. They want to acknowledge you've read it immediately. Now, another quiz question: could an employer change the handbook just like that and just send out a new copy to cure a problem that you've had with employees? Employee just unilaterally without making a new contract with them? Yes, good. An employer can put it right in the handbook, but it should be in the handbook. This handbook can be unilaterally modified by the employer at any time for any reason. So if you're concerned about the reason you had for modifying it, you'll at least be better off to say, well, the reason was my business. It was for any reason. I'm not saying that you can be defended for being discriminatory about that. You'll still have potential problems with that, but at least the handbook can serve you on an ongoing basis in the way that you want it to. Now, I'm going to talk about, there's a lot more to say, by the way, about employee handbook, but I'm going to go on to the next issue. And I'm going to talk about harassment a little bit, because it's rampant in today's companies. I've gone into companies for one reason, and then suddenly I discover a spate of emails that appear to be clear sexual harassment. And I bring it up, brought it to the company, they're not concerned about it. Want to address it. A lot of companies don't recognize it, they don't take it that seriously. In this age of texting, messaging, it's a lot easier for cowards to jump in and send messages to people. That are of a harassing basis, especially sexually. That's the key one that people sue about. At this date, it's not illegal to bully somebody in the workplace, unless there's the idea about legislating that. We have bullying legislation in the schools, but nothing yet for the workplace. But anytime you hit upon any protected class involving the bullying, it might have to do with bodily characteristics, representing being part of a protected class, handicap, color, anything else. Now you're in very dangerous ground, even if there's an implication that you're discriminating against them. So I'm going to touch a little bit about harassment, because the hiring process doesn't just mean you have to be concerned about the hiring process itself. The moment they step foot in your office, there are people who habitually sue employers for harassment, sexual harassment, and it can become their word against yours. So when you have a policy in place for sexual harassment in that handbook, you want to make sure it gives them the ability to report to somebody outside of the company who's an HR expert or an attorney. Because when you're a solopreneur, if you are perceived to be sexually harassing somebody, you may perceive it because the way you look at them, something you wrote down is misperceived, that they have a way to report that if they find the claim, well, it may be very uncomfortable the way I was being treated. I felt it reflected sexual harassment. Now that can be immediately investigated, because until that required report is made to the person on the outside who's the investigator, they can't claim that the company had any chance to investigate. The way the law reads is that the employer has a good defense once they can show that they promptly and thoroughly investigated a claim and dealt with it. So the fear isn't so much about sexual harassment or other types of harassment, but it's that it's not discovered timely because there was no provision in place for people to report it, and that the person was afraid to report it because to the employer because they were intimidated, and the very nature of the claim of harassment is I feel intimidated in that office environment, and I don't dare make it claim because, or even a complaint because I could be terminated immediately, and I couldn't afford to be terminated. Now, a lot of the employment laws, a little more general again, apply to varying numbers of employees in the company. And so some things are applicable with your 20 employees, some things are applicable with your 40 employees. And as I said earlier, majority of laws are applicable to an employer from one and above, including the Minnesota Human Rights Act. Now, because the Minnesota Human Rights Act is where a lot of people go when they've been terminated because they want to claim some sort of discrimination, I'm going to go over some of the primary areas that they look for at the Minnesota Department of Human Rights. One is discrimination based on sex and sexual orientation included. So we're still waiting for the Supreme Court to give us more indication about whether sexual orientation is discrimination is part of Title VII federal law. It's definitely been there since 1995 in the Minnesota Human Rights Act. I actually wrote an extensive article about that back in 95 when it was passed. So if anyone wants to see that article, it's 25 years out of date, but it does really detail the history. It's pretty interesting how that came to be in Minnesota. We were somewhat pioneers on that issue. Talked earlier about marital status. What about asking somebody, are you divorced? I heard you're divorced. Is that okay to ask? No, it's still your marital status, even though you're not married to the person. Status with regard to public assistance. Can you ask them, are you on welfare? Oh, that's in fact makes you part of a protected class as far as the Minnesota Human Rights Act is concerned. What about if they're a member or have an activity in a local commission of some type? Would that be a protected class, whether they're a member in a local commission? And are we part of this Human Rights Commission? If it's on your resume, you can certainly be asked about it. But you want to be careful to ask and or anything about it. It only pertains to job description. We're asking about your involvement in the Human Rights Commission because part of this job is to be an advocate for human rights, not to be a qualification of the position. If you really ask Andrew, are you on this commission for human rights, and he doesn't get the job, you can come back and say, well, the Minnesota Department of Human Rights specifically refers to membership in a local commission or an activity in a local commission if you're not a member. And as a result, they're discriminating because we didn't like that I'm involved in human rights. That Goldstein, his employer, is very conservative, and he discriminated against me for that activity. Disability, of course. Disability has different definitions, depending on which law we're referring to. Age, we talked about earlier, even age 18 can result, anybody over 18 can say there was age discrimination. And the familial status we talked about could be as broad as being a foster parent. Now, what do you do if the person, lost their thought there for a moment. Okay, on to the next thing. What about discussion of wages? That's what they earned in the prior employment. There are laws against that. It's evolving as we speak. And the concern is that, according to Women's Economic Security Act, if there are 21 or more employed, there's evolving federal law that for the protection of equal pay for women, you don't want to be looking at what somebody was previously earning, because then we promote and continue the practice of discriminatory pay for women. And so that's why the laws are now cracking down on the ability to ask people about past wages. I'm going to take a little time for questions here because I have so much more that I could be covering. We talked about the rest of the conviction records, drug testing. I'm just going to insert this. I did a seminar here a couple of days ago about drug testing. And there is a Minnesota law against drug testing that doesn't follow the exact procedures prescribed by the Minnesota Drug and Alcohol Testing in the Workplace Act. There was a human resource person present who indicated their company, more than 100 employees, drug tests, but they do not, she does not keep a copy on her desk or frequently check this act to see if they're complying with it. They've just been going as the course goes on and requesting people to drug test. We talked earlier on, they have to sign an authorization for being drug tested. You have to comply with your request to be retested. If they didn't think that the result was accurate, you provide them with the results. And if they want to retest, they be required to pay for the retest. So there's a little bit of a protection for the employer there, but there are lawyers who make a living doing nothing but suing employers for violations of that law, which is the Minnesota law against improper drug testing. What about pregnancy accommodations? Solepreneur, I mean, you have to be concerned about pregnancy accommodation.
Yeah, that's it.
And then someone had already
There's a Women's Security Act that requires employers with 21 or more employees to provide reasonable accommodation to employees with health conditions related to pregnancy. So there's a lot you have to do if you were to grow to a larger number. My advice would be make any accommodation that you can reasonably make for somebody who's pregnant, because they can come back and say that their pregnancy combines with a handicap disability of some point. Their pregnancy is limiting their ability to perform daily work functions. And since we're winding down on time here, employees who are upset whether they're not being accommodated for something like pregnancy can come back and sue, not so much that they have a solid legal violation, but more so because they're very angry at the employer. That's their mode of retaliation, is to sue. It's been shown that employees who come back and they're surveyed having sued, anger at the employer is a primary one. One of them often comes from being fired by the telephone. Fired an employee by telephone, the employer can say, I'm sorry, the person who was terminated can come back and sue and have nothing more in reality than they're angry about the telephone conversation. They can dig for something that happened in the employment that they can somehow find a lawyer to turn into a claim, or at least you're being hassled by the Minnesota Department of Human Rights because they perceive that one of these other conditions would be violated by it. I'm going to talk just briefly about retaliation, because they're finding the EOC and other agencies, the Minnesota Department of Human Rights, are addressing an ever-increasing number of retaliation claims. Those are people that brought a claim against an employer or made a complaint against the employer, and they're feeling retaliated against by a demotion, terminated, and so it's become an overlay for a huge number of claims. And there's even a court decision that has indicated even if the employee's original claim was frivolous, should have been made, basically they were faking something, but they still suffered retaliation because on the face of it, the employer heard this complaint, the complaint on the face of it could have had legitimacy. The employer was still found to be liable for retaliation, so they pay substantial damages because they engaged in retaliatory behavior of termination or otherwise, because they thought there might have been a claim there, even if the original person was a bad actor who didn't really have legitimate claim. So, and we've got 5 minutes left. If something I've said raises a question you want me to clarify, I'm glad to talk about that.
Charlie, you mentioned about past wages, not asking about past wages. Has that changed over the last few years, or because I distinctly remember filling out applications where it said, where it would ask, all right, where did you work and what was your pay range back then? I'm just wondering if that's a recent law or.
It's recent and evolving.
Okay.
I don't have the exact year that they initiated that. I was concerned myself with the here and now.
Yeah.
History I had to put all the history in my head, it would explode.
This has
But
exploded.
but the amusing that, it may have been an application that you didn't, that wasn't correct, that shouldn't have been the way it read. They may be using an application you've been using for years and years.
Right.
The lawyer has looked at it, updated. There's another danger, to make sure the application itself that you're using, of course, is compliant with current laws. Now, what do you do if there's an area of law and there is a local law regarding it? An example would be wages and overtime. And there's local law, there's state law, there's federal law. I asked on Tuesday, what does the employer do with that situation? Which law do you make sure you comply with? And he said, well, the most local law, because that's the actual local area. That's not the right answer. The right answer is you do whatever is most favorable to the employee.
Oh.
Because any one of those agencies or courts can say you broke local law, you broke the Minneapolis Sick and Safe Leave ordinance. And so if you do anything to violate any of those three laws, it's not a defense to say, well, I was complying with federal law, complying with state law. That just happened to be the local law, but it's more liberal. For example, overtime pay in Minnesota, which is 48 versus the state is 40. State versus federal, 40 versus 48. So just because you comply with paying overtime correctly with the state law doesn't mean you comply with the federal law. I don't think you just say that. Minimum wage is different, depending on the number of employees. Just a little bit more, of course, when you're an employer that has more employees. What important points that they have missed here that I wanted to cover. So if you smell a problem with a new employee, the time to act on it is right away. I give this analogy. If you find some food in the refrigerator that's going bad, you leave it there, hope it's going to recover, start smelling better. No, since the situation doesn't smell good, the smell test is what you want to use to go approach a professional, a resource person or an attorney and say, this person seems uncomfortable in the environment and I want to do something about that. One quick war story, I had a receptionist who was being sexually harassed. It went on for a while, we had no idea what was going on. She was becoming very quiet, and my paralegal smelled the problem, talked to the paralegal, and determined that there was texting going on that was inappropriate. So had we waited for some kind of more formal complaint, it may never have come and been a much bigger situation. So you don't want to take the wait and see attitude with regard to performing the law. You don't want to take the wait and see attitude with regard to behaviors. And the longer a person is there who is unhappy or not fitting into the environment or raises potential legal issues, the sooner you deal with it, the less large it gets. It looks like you're going to go see an attorney and pay money to put out a fire. So that's what employers spend a lot of their time doing, is putting out fires when they could have just kept the ground moist so that no fire broke out in the first place.
Like that. All
Right,
right.
it's approaching, so.
Thank you, Charlie. Good job. Last of all the nuggets, everyone? Woo-hoo. Well, we are raising the roof at office centers this month. We have a lot of stuff going on, starting with tomorrow, right, Casey? Tomorrow on June 1st, our amazing fearless leader will have been in this business for 38 years.
Wow.
That would be Saturday. So of course there has to be a party tomorrow since we won't be here on Saturday. So it's going to be cupcakes from 1 o'clock to 3 o'clock. Everybody that attends gets a free pass to use one of our podcast rooms here at Park or at our Woodbury location. And there's something else with that, Blackjack Friday. So come in. You're coming to try your luck. On Sunday, our team is going to be attending the Randy Shaver Foundation Gala to support our one community member. And we're also going to sponsor the golf tournament on Monday, June 3rd. We're going to have much of our management team there, so it'll be a little limited on staff, but we'll still be rolling out the red carpet for everyone. On Thursday, June 6th, we'll be raising the roof at our park networking. That one is growing and growing. So here we have it from 9 a.m. to 10 a.m. next Thursday already. Tuesday, the 18th, we have our Slice of Woodbury from 11:30 to 1 o'clock at our Woodbury location. Last month, we had 25 people register and 54 show up. We've learned to get extra pizza. So Thursday, June 20th, we're at our Minnetonka location, and it's 2 networking events for the price of free. We are going to be co-sponsoring with New Business Minnesota. They're going to do their advisory board meeting while we do our Thirsty Thursday. And then we're all the way back to June 27th, where we're gonna have Power Lunch again. That's gonna be at our Woodbury location. Susie Hunn is going to be conducting a networking workshop, that's gonna be titled, let's see, Clarify Your Brand, Empower Your Business. So let's check out our website. If you have anybody, we're all about, any new members are awesome, and we love to pay referral rewards, so anybody who wants free day passes, we're all about that too. So,
Before anybody leaves, the sheet going around, I think, got there, Casey, so that you acknowledge that nothing here is legal advice. Not gonna do anything or not do anything based on anything I said today.
there you go. And there's a survey in front of everybody too. So, other than that, have a great day. Thanks for attending. Thank you. I introduced myself. I'm Lisa.